Okay, I'm gonna start. So welcome everybody. I thank you all for joining. It is rather timely to be discussing AI. There are three big developments this week, just remarkable, including this morning. And as initial comment, any lawyers out there that are looking for MCLE credit, we will be sending out information on how to get MCLE credit in the chat box. I will be taking questions at the end for as long as people want to stay and put the questions at the bottom in the Q&A box, not in the chat box. And I would ask everybody to keep the questions as short as possible so that we can get to them. If they're too long, we just won't be able to understand them, much less get to them. Just briefly on my background, I've been practicing over 40 years, and I was an adjunct professor at UCLA Law School and Business School for many years. I'm the author of a very popular book called The Biz that I'll pull up on the screen at the end. And I'm the author of a treatise called Taxation of the Entertainment Industry. I have a monthly column in Forbes, and my greatest claim to fame that I'm the most proud of was being named Lifetime Legal Legend by the Hollywood Reporter. And so that's just kind of a brief. And I practice in this, obviously in the entertainment industry, but and a number of clients doing AI on the content side, creating content, all kind of content, podcasts, um, films, video, shorts, interactive on screen. So I've been in the midst of this AI revolution in a very big way. This week, there were three big developments that I want to touch on first that are just unbelievable that they just happened. The first one is that there was a verdict yesterday holding that Meta was liable for addicting children to that their algorithms were addictive. And just yesterday also there was a verdict against Meta and YouTube on a very similar claim in Los Angeles. The first one was in New Mexico. While those involve social media companies, I will tell you those claims are absolutely going to apply to AI chat box. There are people that talk to chat box as though it's their friend. They talk to Gemini. There's been claims of people falling in love with it. There's been claims of people committing suicide. So those judgments are worth taking a look at because there will be class action claims, no question, against the AI companies on that. Second thing that happened, very interestingly, was that OpenAI gave up on Sora yesterday and terminated it. And the fundamental reason that they did is everything we're going to talk about today. All the claims that were made against Sora they got claims for uploading copyright infringement, downloading copyright infringement, right of publicity, um, claims by the guilds, claims by foreign countries. It was just overwhelming, and they just said this is not worth it. So we'll be discussing today the claims that were made against it and the implications of that for other AI companies. The third thing that happened, just remarkably, is on Friday, Trump gave a executive order, which was called an AI framework, that listed their priorities on AI, basically giving a request to Congress on a number of issues that we'll be talking about today, and arguing for preemption of state laws that we'll be talking about, and doing numerous things. And I'm gonna bake that into this program today. But so the timing of these is just remarkable. You have three big developments on AI just in the last week. The All right, now let's start with, just as a background, really, what can AI do? And the answer is AI can do anything. AI can go all the way from perfect replication of me on this seminar. I mean, the question in a year or two, you will not know whether this is actually me doing this seminar or whether it is whether it's AI. You just will not be able to tell. So it can go all the way from perfect imitation all the way to total fantasy and anywhere in between. It can do it for music, books, screenplays, films, photographs, Shorts, obviously, we was Sora and now C Dance. No question that full length AI films are coming. There is no question that that is next up at bat. My guess is it's going to be this year. And I would not be surprised if Tilly Norwood is the actress that is you know portrayed in it. Because the first AI actress. And AI can do text to speech. Oh, I've got clients doing podcasts using the voice of famous actors with their consent. It can do text to video, so you can write it out what you want, and then it'll do it. And with my view is that it will be as good, if not better, creatively than humans. And I'm sorry to say that, but I think that I know the argument is we're all divinely inspired to be remarkably uniquely creative, and with apologies, I don't buy it. We're all digits and neurons and zeros and ones ultimately, and computers have more than we do, and particularly with these huge data centers. So my view is you need to embrace it as a tool. You need to understand it. You need to get behind it and use it and not fight it. If you fight it, you're just a Luddite. You'll get run over by the tractors of history and the sewing gen mills. You can't. It's coming. You can't stop it. So embrace it. That's my 2 cents. Um, Big issues. Let's do copyright. There are really three or four big issues with copyright. Uploading, downloading, um, and then the protecting whether you can protect what you create with AI. And then fourth is, do you lose AI? Do you lose your own copyrights when you use an AI system? And we'll go through each of those. So the first big one that's the big litigation right now is uploading. And everybody and their mother is suing because everything's getting uploaded by the AI companies. They're scooping up everything in the world. And I mean, with remarkable ferocity and time. I've asked questions to AI about events that have occurred within the last half hour, and it'll know. So it's clearly scooping up news from somewhere. And I'm sure my books have been uploaded and are being used somehow or other. So everything's being uploaded. Now the question is, the copying for the uploading is copyright. That is no question. It is prima facie copyright infringement. With a drum roll, the big question is it fair use? And and that's the defense that you always hear. And it is a rule with your heart question. Do you think it's fair? And more importantly, is that there's a bunch of factors in the statute, but the one that is the most critical is does the does the copying impinge on the market of the original work? And that is the key. The key is really and then you get to what is the market for the original work? And there's basically there's now a split really in the case law. There was an important case a year ago, Ross versus Thomas Reuters versus Ross, that held that uploading was not fair use, at least if it was by a competitor. So if a competitor was uploading content to compete with the original work, that uploading itself was copyright infringement, regardless of the output. There was two cases later on in California that held that it was fair use, and this is the Anthropic case and the Meta case, and it was uploading massive amounts of books, and they held that it was fair use. And those cases looked to whether or not the output competed with the books. And there was no in the cases the arguments and the lawyers were making did not relate to the output. It was just the uploading. In my humble opinion, the market now is the uploading, not the output, and that the two California cases I believe, are wrong because the market is now uploading. And the New York Times has a case pending, and they're all over this. They have made very clear in their arguments that they're not complaining about the use of the output competing with their news, although it does. What they're saying is all these people are asking us to upload and they're willing to pay for it, and that's now our market. And you, whether it's whoever, Anthropic, OpenAI, by uploading our New York Times articles, you are usurpating our market. You're usurping our market that we could otherwise charge for. And I believe that is correct. But you now have a split, and this is going to go up to the Supreme Court. And um, and and now this is where it gets interesting because that AI report, so the AI framework that Trump announced on Friday said that in his infinite wisdom that uploading was fair use. And so he just said it was very funny. They said on Friday that the AI framework said three completely inconsistent things. One is they said it's fair use. We think it's fair use. Second, they said, oh, but courts should decide. And then they said Congress should pass a law mandating payments to the content owners that was uploaded. So fair use, which means no payment. Congress should pass laws that requires payments, and then courts should decide. So it was rather interesting. But there was a very loud statement that they thought uploading was, and Trump has previously said that. And the question is whether his lapdogs on the Supreme Court will follow his lead and adopt that when this goes up to the Supreme Court, and it is and which is you know possible, likely. So I would have said that a few months ago I would have said the Supreme Court, in my view, will adopt the New York Times approach and my approach, which is that the market is being usurped. Uh, Given Trump's and new statement, it is possible the Supreme Court will go the other way. So this is still going to be a very very open issue. I do want to just briefly mention that there's some confusion because Anthropic settled another issue for a significant amount of money, $1.5 billion, and some people are interpreting that as that it was relating to uploading. It was a different issue. So the California cases on the Anthropic one held that uploading was allowed. Um, One interesting issue on the uploading is where does it occur? And because the copying is the copyright is a country by country question, and if you upload outside the United States, then the copying for uploading would not be a U.S. copyright claim. You could bring a claim maybe on the output, which we'll get to. But it's interesting that there was a UK case that threw out a claim because the copying had occurred in the U.S. So you can see that where it occurs matters. What is interesting is that no one is doing the copying in some country that doesn't have copyright protection, or that off, or no framework for protection. Pick any country, any island in the middle of the Pacific, or Zimbabwe, who knows. Um, so um, and last comment on uploading, if you're not protected, if it is fair use defense, you cannot bring a state law claim because the Copyright Act preempts state law claims on this question. Okay. Next, output. So on the output side, there the question is it a derivative work based on the original, either because it's substantially similar or it is exactly like it. Like if you look at what Midjourney was spitting out from the studios, it was it was exact copies of Star Wars and all the other IP that the studios owned. So step one, is it an infringing either direct copy, or is it a derivative work? And a lot of the claims that are being made are hey, you uploaded our content, therefore we must be in the output somewhere. We're in there somewhere. Those claims are losing because that's not the test. The test is not we're in there somewhere. That like all art is always based on prior art. People are, whether it's a human or a computer, is influenced by prior art. So the fact that the output is influenced is not enough. What is winning and will win is the identical, whether it's the Star Wars version, all the studio ripoffs, the Batmans of the world, that those will win. That is copyright infringement. That's still step one. Yes, it's a derivative work. Step two is who do you sue? And personal use at home is fair use, that's for sure. So if somebody's just playing with it on their computer, that's allowed. Um, how about the companies that post it, like YouTube? If somebody posts up, they use AI, they do something, they put it on YouTube, and the YouTubes of the world are protected by Section 230 of the Communications Decency Act. And what you do is you have to send a takedown notice, tell them to take it down under the Digital Millennium Copyright Act. And so YouTube has protection for that. So you can do a takedown, but you're not going to get a claim for, you're not going to get damages. But how about the AI companies? And this is the lawsuit that's going on by the studios right now, Disney, Universal, Warner, against Midjourney and others. And the claim is that they are aiding, fundamentally, it's they're aiding and abetting and facilitating this copyright infringement and encouraging it. And it is similar to the Napster slash Grokster claim that was when they were, pirating music. And it's a very solid, good claim. It's a state law. It's fundamentally a state law claim. And um, what's, you know, what's good about it is that I think it's a solid claim. However, on Friday, Trump announced, quote, states, and I will quote, states should not be permitted to penalize AI developers for a third party's unlawful conduct involving their models. So Trump has said basically that the AI companies should not be liable, that the because the users are doing something bad. Um, I think that flies in the face of reality. I think it is a Napster Grokster claim. I think they should be liable for it. Midjourney in particular is just in your face, encouraging it, posting it on their site, telling people to, I mean, it's Napster and Grokster on steroids. So that's my personal view. Um, on the other side, what Napster and what Midjourney and the AI companies will say is, hey, this is like the Betamax in the Sony case. And if you remember, Betamax allowed copying of uh, you could use a Betamax to copy off the TV. And that's what they're saying. We're just a copier. We're a tool, but I think that they go way past the line. I think it is intentionally promoting infringement, and I think it should be liable, but to be decided, obviously, to be decided. The third thing on output is you get to this fair use defense. So it's step one, is it derivative? Step two, who do you sue? Step three, is it fair use? And again, you rule with your heart. And there used to be a transformative defense that if you modified it in some way, you modified the original in some unique, creative way, that was itself a fair use defense. That got thrown out by the Supreme Court in the Andy Warhol case involving a colorized portrait of Prince that was taken from a photograph. And so that the classic transformative defense no longer applies to copyright. And the bottom line is that in most cases, if it is a derivative work, if you get past you find who to sue, it's a derivative work. In most cases, it will not qualify for the fair use defense. It is almost certainly at that point probably competing with the original, and unless unless it's being used in some different, unique way, or there are the classic, the parody, newsworthy, something like that. All right. Third thing on copyright is the holding by now the Copyright Office and the courts that you cannot protect with copyright what is created by AI. And so that you just no copyright protection. And you can't get, if you can't get protected under copyright, you can't get protected under state law either because of preemption. And you can't do a takedown notice because that only applies to copyright. So if your AI generated material ends up on by other people using it, you can't take it down, you can't protect it. And Disney just fired a month ago, 2 months ago, fired a animator that was using AI. And I'm betting there's one of two reasons why, but this is one reason. They were probably concerned that they can't protect whatever is created with AI with copyright. And so that's the last thing you want is to be spending money on content that cannot be protected. What's happening is that people are pushing the boundaries and saying, I used AI, I told it what to do, and aren't I creative? I modified the output somewhat. I gave it further instructions, and it really was like it's like Photoshop. You see, it's really I really was creative and did this, and th um, those cases are pending. It'll depend on the facts and circumstances. There's no clear line. It'll be litigation heaven for years to come. That what I think is going to happen as a practical matter is what I call the I forgot defense. I guarantee you what people will do is register it in the Copyright Office and I forgot that it was created by AI. I did it and litigate later if anybody figures it out. And I guarantee you that's what's going to happen. Um, if you are if you're worried about protecting AI created content, there's two things you can do. One is start at the beginning and have a human draw, write, whatever it is that you want to have done, have them sign in blood that they did it as an individual, prove it, whether it's a treatment, whether it's a picture of something, whatever it is, and start everything from there will become a derivative work and will be protected, even if it's created by AI. So that's one way to go at it. Second way is take the final output and intersperse human created elements in it, whether it's colorization or modify, actually prove that a human did something with the final visual elements. And that is another way to go at it. And as long as it's difficult for people to parse out the AI created versus human created, no one will bother trying to do it. So that's the other way to try to protect it. And the fourth thing on copyright that I want to warn everybody about is that uploading if you upload copyrighted protected material to particular AI services, you will lose the copyright protection in that because the terms of service often make it public domain. And the one in particular that I've noticed is Midjourney. If you uploaded copyright material to Midjourney, the terms of service basically say that it becomes public domain. And I'm guessing that this may be another reason that Disney was not very fond of one of their animators using AI, because if they uploaded Mickey Mouse or not, well, that's expired. But if they uploaded new Star Wars, who knows what, there is the risk that Midjourney would say, "Aha, if that person did it with authority of the owner, then it could be treated as public domain, which would not be a happy day for Disney." So look out for terms of service. You've got to read them carefully. Some are protective, some are not. I've gone through all of them, and you just have to be careful. Uh, Next big issue on AI, trademark. It's worth talking about trademark. And the fundamental rule with trademark is very different than copyright. Is the fundamental rule is will there be consumer confusion as to the source of the goods? That you always have to ask that question. It is okay to have trademarks in films. If you have a film where somebody's carrying a Gucci handbag or driving a Mercedes or going to a McDonald's, that's fine. I get, people ask this question all the time because there's no reasonable consumer watching that film would think that the film was produced by get, Gucci or McDonald's or Mercedes. Where AI has gotten in trouble is my favorite one was Stable Diffusion obviously uploaded all the stuff from Getty and then spit out different photos that look different, but it said on it Getty Images, which is the trademark that Getty uses on their photos, and that kind of gave it away. So that was obviously trademark infringement by Stable Diffusion of Getty, and that was a valid lawsuit. You could imagine too if you did a film and using AI and it said presented by Disney or Star Wars on the as the title of the film, that's not going to go over well. That'll definitely be trademark infringement. Um, One thing that is interesting is whether as can you protect AI created output with trademark? And the one in particular that I think is interesting is Tilly Norwood. And let's assume that Tilly Norwood she is created by AI. And I'm going to assume for this discussion from ground, no one drew her original picture. So she cannot be protected by copyright. So how are they protecting Tilly Norwood? It's got to be with trademark. And how do you do that? You use the image in commerce, you identify it, you put a name on it. Good job, Tilly Norwood. Put a unique name, Tilly Norwood. Um, Put it out in the public that you're using it, and file a U.S. trademark note registration for it. And I just went and checked yesterday, and oh, guess what? They had registered Tilly Norwood for trademark protection in the U.S. Copyright Office several months ago. And so that is exactly what they are trying to do. And any other people that are going to try to create AI created actors are going to do the same thing. So if you can't get copyright protection, the answer is you're going to try to get trademark protection. And that's exactly what they're trying to do with Tilly Norwood. Copyright, trademark, next, right of publicity. Right of publicity. Next big category of claims, lawsuits. This is part of what shut down Sora. It's a state by state question, fundamentally, that individuals, whether they're celebrities or not, have a prima facie claim if somebody is using their name or image in some manner they didn't approve. And obviously, celebrities in particular were not happy with Sora using their images to do short films, and they were suing under state law. The problem is, as opposed to copyright and trademark, right of publicity is not a federal IP protected. It is state by state, and the states are all over the board in who they protect, what they protect, where they protect. It's a mess. And there's a lot of defenses depending on the state. Some states have the old transformative test. It's similar to what I mentioned in copyright, that if you mush it up in some way, you take the person's image and change it in some way, it's transformative and therefore it's allowed, even if it's recognizable as the person. Some states have a copyright preemption defense, that if it's incorporated into some kind of a copyrighted work, that's protected. And then other states California has special laws on right of publicity for AI. There used to be, for example, a defense that if you took a deceased celebrity's image and used it in entertainment, that was permitted. That got repealed with respect to digital uses using AI as of a year ago. As of January 1, 2025, you can no longer use digital replicas of deceased celebrities in entertainment. Similarly, and then obviously digital replicas is being used. That's a footnote. That's AI. Um, California also passed a law that said that individuals could no longer sign away their right to create digital replicas of them unless several exceptions apply, and those exceptions are big enough to swallow the rule. So, California, for example, if you're represented by a lawyer, you can give away your rights. Um, if it's used for something that you would not personally do, then it's allowed. So there is a California law on these issues. Um, Again, state by state, who does it protect? Does it only protect but residents of California as opposed to outside of California? What about uses outside? So it's kind of it's a bit of a mess. If you have on all these claims, let's do the Sora clips is a perfect one. Who do you sue? If you're one of this, the state of there was Martin Luther King was objecting, and there was a lot of celebrities were objecting. Um, do you sue the YouTubes of the world where it's posted? And there's a split of authority on that question. Um, whether the Section 230 of the Communication Decency Act applies to right of publicity. The Ninth Circuit says yes, and that is protected, and that therefore you cannot sue YouTube. The Third Circuit says no, and that you can sue YouTube. So you will get um, people obviously forum shopping to decide where to sue, so that depending on what circuit take you cannot do a takedown notice for right of publicity. That only applies to copyright. So in the Ninth Circuit, you can't sue YouTube, and you can't do a takedown notice for if it's a right of publicity claim. Can you sue the AI companies that are permitting this? This is why everybody was suing Sora. And obviously Sora's of the world, open AIs are going to say, we didn't do it. Our customers did it. We're like Betamax. We're just a machine. We just work, we just work here. And this again, it's going to be exactly the issue of 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 Grokster and Napster on the one hand and Betamax on the other. And is it intentionally permitting infringement? I think the short answer is yes. And then you have the exact same issue of the Trump announcement on Friday, which said that the AI companies should not be liable for what their customers do. And so throw that into the mix. Although it's supposedly left for Congress to do something about it. In June, last June, New York passed legislation that required advertisements that use digital replicas, or they call it synthetic performers. They required the advertisements to disclose that fact unless it was a portrayal of a real person, in which case presumably they got consent. Like if it was of a famous celebrity, that then you don't need to disclose it, but presumably either the celebrity could sue or they gave consent. Um, or it was an advertisement for a film that used AI. So now you've got California legislation, specifically the federal legislation on AI. You've got the general framework of the panoply of state laws. Now we get to let's talk about where the federal legislation stands. They passed a year ago a law called the Take It Down Act, actually got passed. It would have been a perfect opportunity to enact federal right of publicity law. It was a swing and a miss. It was limited to sexual acts and nudes. And so, nibbled at the edges. It's kind of a right of publicity statute, but limited to basically simulated sexual acts or nudes without consent. There is a law called a pending law called No Fakes that is pending in Congress, that is a broader right of publicity claim supported by the guilds. And um, Trump on Friday announced that basically that should be enacted because he said there should be a federal right of publicity law. And then he added the twist, though, that it should preempt state laws and that the federal laws should preempt the California law, the New York law, and any other laws dealing with AI. But I'm just focused on right of publicity. So it effectively what's interesting about it on a kind of a side note is the the preemption of the proposal, and there was a proposal, would preempt state laws dealing with, quote, artificial intelligence. California's law actually uses the word digital replica, and New York law uses the word synthetic performer. They don't use the words AI. So it'll be an interesting if they do pass this federal preemption, whether it in fact overrules the California and New York law, because they technically don't use that word of AI. Okay, next up at bat. So we've done copyright, trademark, right of publicity, defamation. Um, AI is defaming people right and left. And so we now apply that to the current law, which is if you're going to in order to have a valid defamation claim against a celebrity or a public figure, you have to, one of the defenses is that you didn't the defendant did not have actual malice. And actual malice is defined as a subjective one. And I will quote the Supreme Court. There must be evidence of to permit the conclusion that the defendant actually had a high degree of awareness of probable falsity, that the defendant had a high degree of awareness of probable falsity. So late last year, in a case Walters versus OpenAI, ChatGPT defamed a public figure, and he sued ChatGPT. And ChatGPT's defense, which was upheld by the court, was and I quote, no one at OpenAI had any way of knowing that the output was false. And so short version of that is that for public figures at least cannot bring a defamation claim against content created by AI because nobody was subjectively aware that it was false because it was spit out by a computer. That was bad enough, but the court went on to say that no reasonable person, quote unquote, would believe what ChatGPT says because it has a warning at the bottom that says that it may be an error and everyone should know that it makes errors because of all the news. That is so bogus and so wrong. People are relying on ChatGPT all the time. I get clients sending me contracts that they've created with ChatGPT, and even if they're bogus, they think it's right. So, but what's important about this holding is that it would defeat all defamation claims, including by non-public figures, because it's not an actual malice issue anymore. It's a you can't the reader shouldn't have relied on it, and that is a very different test, and that effectively wipes out any defamation claim against anything that AI spits out, and I think that's wrong. I just think that's just nutty, but because people are relying. First, I think it's wrong even for public figures because people are relying on ChatGPT and on Gemini all the time. I mean, they just do. They will get to the end of lawyers in particular. In particular, lawyers are relying on it, which is, the weirdest. Next, so dropping down the list of claims. The next big claim is what I call is state law claims based on false advertising, unfair business practice, or fraud. Just group it all together. You did something bad. And a good example of this, it didn't involve AI, but it involved using digital effects to get the same effect. Was Sony did a record of Michael Jackson's songs. They claimed it was done by Michael Jackson, that they had found songs that he supposedly hadn't recorded or hadn't published before his death. And it turned out they were generated by digital effects, and or Sony was sued and lost. And that was and by the way, they were sued by an associate in our firm. It was remarkable tenacity. And what's interesting about that is that, again, on Trump on Friday said that Congress should preempt state laws, all state laws that deal with AI, other than laws, quote, that protect children, prevent fraud, and protect consumers. And so the question is, where does that fall if you do bring a claim on this, and if Trump's edicts become law, what will the outcome actually be on these kind of claims? Is it intended to overrule the kind of, if Michael Jackson had been created, that song had been created by AI, would that be preempted by some act that Congress does? Stay tuned to this station. This is yet to be discerned. Next issue. You're a distributor, you're a studio, you're a sales agent, you're a whatever, and you've been sold a film, a script, something, a treatment, whatever it is. How do you know that it wasn't created by AI, in which case what you have is worthless because anybody can rip it off? And so what becomes critical now are reps and warranties, that it wasn't created by AI. And even if it was created by humans, that you didn't upload it to Midjourney or another service where you lost it, became public domain. So it can work in both directions. Is it protected by AI, or if it was protected by copyright, did you lose it? So reps and warranties, and by the way, backed up by someone who's got deep pockets, because if your distributor's out there and spending millions of dollars, and it turns out they don't own stuff, they're in trouble. One thing they can do is AI detection software, but it has now become an arms race as the AI software gets detection software gets better, so does the AI gets better, and so it's become a bit of an arms race to see who will win. And right now, AI is winning. AI creation is winning. The detection is getting overwhelmed by it's getting too good. The AI created content is getting so good that the AI detection can't pick it up. So what do you do? I don't know. If I was a distributor, I would be extremely nervous these days. Reputation is going to matter like it always does. Deep pockets, reps and warranties, but look out. Next, let's talk about the guilds. And by the way, the guild agreements are coming up this year, so stay tuned for what could be a fun ride. Now, I'm going to give you my predictions on this, but I'll tell you where it stands right now. Here's where it stands right now. The DGA got a 3-year kick down the road. They said their contract said that the studios could not replace DGA members with AI. That's fascinating. The studios agreed to it. And keep this in mind, you could not replace a DGA member with AI. The WGA, in their contract 3 years ago, said studios, you can use AI to do writing, but it won't count as literary material for purposes of credit and compensation. So if whoever touches that AI created content becomes the deemed writer of it. If AI creates a treatment and you give it to a writer, that writer will be deemed to have created the treatment for purposes of credit and compensation. It didn't stop the studios from using AI. That was kind of a widely misunderstood issue. They could use it. And now the real question is, what happens if studios just bypass WGA members altogether? What if they just say skip writers? We'll use AI. The problem, obviously, is that whatever's created won't be protected by copyright. But what they could do if they're nasty is you could have a non-WGA writer write a treatment or buy a treatment from somebody and then have AI do the rest. And in that case, they could, in theory, sidestep the WGA. SAG, let's talk about SAG. SAG, what they said is fundamentally, we're going to protect our members from the use of their images by AI. You have to, if you do try to get it, it has to be clear and conspicuous. You have to describe what you're going to do, and more importantly, they get residuals. They get residuals on it. However, if the studios do and bypass the SAG completely and do a synthetic performer, then the agreement simply says that the studios have to negotiate with SAG for, quote, appropriate consideration, if any. And I guarantee you the studio's opening bid is going to be the if any means zero, because why do we owe you SAG anything for creating a synthetic performer? This is going to be this is going to be what's up for debate when the guilds agreement expire this year. And here's my prediction. My prediction is, with a drum roll, there will be no strike, and because everyone's too exhausted from the last strike, and everyone got hammered, and life is too short, and life sucks, and then you die. And so that's, I think, I believe that's what will happen. However, I do think this is make or break it for the guilds. And if I was a guild, if I was the WGA or SAG, I would strike. And because it's over, man. I'm telling with Tilly Norwood for SAG, it's over. And for writers, the same thing. They can get replaced too. Now, what's interesting is what the DGA did, and what I would think that SAG and the WGA would do is say you can't replace a member using AI. And the studios, the comeback would be, hey, you guilds, you only have jurisdiction over employees. You don't have jurisdiction over special effects, computers, machinery, or AI. And that could be a heavily litigated issue. What's interesting is that the studios agreed to it, though, with the DGA. So to some extent, they have kind of opened the door on this argument. And I wouldn't be surprised if the WGA and the guilds and the SAG said, we want the same thing. We just want an agreement that you will not replace us using AI. And it'll be interesting what the studios say. And the gloves are off. So everyone should stay tuned. But I will tell you, if the guilds don't get that provision, and if they don't strike over that issue, they're in deep trouble. All right, they just are. Okay. Last, let's talk about some of these issues in the context of one of the early things that came up, and it's fascinating. It was Heart on My Sleeve, a song supposedly by Drake and Weeknd, and it was showed up on YouTube. And so let's just go through some of the issues that we've discussed in the context of that. And it's interesting because it was one of the first examples of this. It was generated by AI, so there's no copyright protection for the output. So that means that anybody could copy and use this song, Heart on My Sleeve. That's interesting. And so no copyright protection, hard to monetize that then. Generally, there would have been no takedown right. Universal, who would, Drake and Weeknd are on Universal, normally would not have been able to do a takedown, except that there was a small clip on there that did use copyrighted material. So Universal was able to do a takedown. One interesting issue is, it was similar to the style of Drake and Weeknd, but it wasn't close enough to their actual songs to be copyright infringement in and of itself. So I don't think that was my own vote. I don't think it was so close that it would be copyright infringement. How about trademark? There was no consumer confusion as to the source because they said this is created by AI. So I think they avoided a trademark claim by doing that. I also think that they avoided a trademark claim, not trademark, a state law fraud, deception, whatever you want to call it, unjust enrichment. They avoided all the state law claims by also saying this is created by AI, as opposed to what Sony did on the Michael Jackson record, which said Michael Jackson did this. This song clearly, they had this thing that said this is created by AI. How about a right of publicity claim, though, by Drake and Weeknd? Their names were mentioned. And so now you get to the state law. What state do they reside in? What states give protection for this? Where do they, if they want to sue YouTube, do they sue in the Ninth Circuit, in which case they'll lose? Do they sue in the Third Circuit, in which case they might win? Is it transformative? Because a lot of states have this defense for that whatever is transformative, and maybe that the claim would be that it was transformative. And so that's an interesting one. They didn't sue, of course, that they didn't sue. Last few other things I want to mention is every day lawyers are getting sanctioned for using AI created briefs. And I just can't believe that. I used to think, oh, the first time this came up 2 years ago, I thought, oh, that'll never happen again. And now it's every day. So all I can say is are you kidding? So please, to the lawyers out there, do not rely on ChatGPT for any citations. You can't really rely on it. It's a wonderful tool, but you can't rely on it without checking on everything. Whether it's math, whether it's citations, it's a wonderful source to get close to something, but you can never, ever rely on it 100%. You've always got to double check. It's a fantastic tool, but I cannot believe that lawyers that are big law firms, submitting briefs with just completely hallucinated citations and quotes and cases, and without checking, are you kidding? So please, for the lawyers out there, don't rely on it, and to the clients out there, don't rely on it to make contracts. I'm now getting clients sending me contracts that are created with AI, and while it's intriguing, it's like having a high school kid do it. It's close but no cigars, and boy, you sure as heck don't want to rely on it. And I would so much rather start with my forms where I've thought them through than start with something that created by AI. Follow up before we get to questions. If anybody has any questions or at all going forward, I love to hear them, because that's how I stay on top of things. I get to hear the crazy stuff that's going on. So you can write me at my email. You can call me with questions anytime. My phone number is 424-208-3264. It's probably on our website. And you can call me with questions. Also, I have a newsletter every month. And if you'd like to be added to the newsletter, all you have to do is send me an email with the word add in the subject line. Just add. My email is smoore, MOORE, at ggfirm.com. So once again, it's smoore@ggfirm.com. And just send me an email with the word add, and I will add you to the newsletter. And it's basically my Forbes column and anything else that comes up. I've got, new developments, things that are happening. I have my course that I taught at UCLA is on YouTube. You can watch my course, pick a topic that interests you. It's broken up. and it's under Sky Moore Attorney. If you go on YouTube and you just search Sky Moore Attorney, you'll find my entire course and um, pick a topic that interests you. And then last but not least, if you don't have it, you should have my book, The Biz. And let's see if I can pull that up and share it. And it's on Amazon. It's on any other place. It's now in its sixth edition. It's very popular. And it covers everything we've talked about today and a whole lot more. Everything in the industry from soup to nuts. And with that, I'm going to take questions. So if anybody uh, has questions, and Brandy is going to read them to me. And with luck, I'll actually know the answers. So Brandy,
Okay.
if you're there, I'm good to go.
Okay, great. Yes, we have several questions here. The first is, what do you see as the core AI contractual provisions for distribution agreements? For example, use of AI in delivery materials, use for dubbing, etc., and for acquisition agreements, reps and warranties, disclosure, underlying materials, future digital use, etc.
The answer to that, yeah, I kind of briefly touched on it. Reps and warranties, indemnity, and against somebody who's actually can pay it, and not the SPV, the single picture vehicle that made the film. You want somebody you're really, and if you can, AI detection software to see if you can fess out what's actually happening. But reps, warranties, and indemnities, that's the answer.
Great. If there is no copyright in an AI created work and an AI movie is created, including actors, sets, locations, music, and all audio, why can't I monetize that work on my own channel?
You can monetize it all you want, but then so can I, and so can my mother, and so can anybody else. So that's the problem with that.
Okay, great. Next question. Can't you parse the metadata on a clip and tell whether it's AI or not? The industry is suggesting an AI rating for film created with AI. What will come of this?
Um, the it is hard to detect it. This is the arms race between detection versus creation. That right now the creation is winning. So that's the answer to that one. I am all for the MPA should have done. I should have said this. The MPA should have done, and I've advocated this, should adopt an AI rating. And that what they should say is to producers, you have to tell us and you have to be honest, and we'll get you if you're not. And they should, in addition to whether it's M, R, PG, it should say AI. I totally agree.
Okay, great. Next question. Are you saying that if we upload a script we wrote to AI for notes, promotional suggestions, etc., that we lose our copyright protections if we filed previously?
That is what I'm telling you. If you load that to Midjourney, unless they've changed the rules, the last time I read the Midjourney rules, when you uploaded your screenplay to get their input, it became public domain. Oh, look out. Yes, that is a serious problem.
Okay.
And probably why Disney fired that animator, or one of the reasons.
Will there be any coverage about the sea of patent filings covering the AI production?
Say it again.
Will there be any coverage about the sea of patent filings covering the AI production?
I don't do patents, so I will pass on that one.
Okay. Do you have a contractual definition of AI you're using in acquisition agreements and distribution agreements?
Best to just leave it to well, yes. Short answer is yes. And it depends on the particular contract. This is, for example, is a digital replica AI, is a synthetic performer AI, voice recognition. The short answer is it depends on the contract and exactly what the purpose is. So it depends.
Okay. What about the IATSE AI provisions and those of Canadian and European guilds and unions and governments, since so many shows are shooting outside the US?
I didn't hear a question. What's the question?
What about the IATSE AI provisions and those of Canadian and European guilds and unions and governments, since so many shows are shooting outside the
Yeah,
US?
I don't understand that question. So
Okay,
there's no question in there really.
okay. Next, got some shout outs here. Do you recommend real celebrities trademark themselves, like Tilly Norwood?
Well, Tilly Norwood is not real. This is the question of whether Brad Pitt can trademark himself. I don't think he needs to. I think celebrities get protection under right of publicity. These attempts to trademark various aspects, I don't think is useful or needed, is the short answer.
Okay. Next, what does the Sora closure signal, if anything, for the broader AI video marketplace?
It signals that all these claims that I've just went through today are real, that they need to think about it, they need to focus. It is going to be a real issue. Now this goes to I think what I believe is that uploading is a copyright infringement. It's not fair use, and therefore there should be content licensing that pays for the uploading. I think that is the ultimate, what I think it should be the fair ultimate outcome. This is right now a split going up to the Supreme Court. You've got the Trump announcement that he thinks it's free game. So this to be this is the mess that we're in that will need to be resolved.
Okay. Next, if I register a trademark in Canada, do I also need to use it in the USA?
You don't need to use it. No, under the Berne Convention, if you get protection anywhere in the world, you get protection in all the countries. So once you then need to go. You should still register it in the U.S. if that's the question. You don't have to use it in the U.S., but you should register it in the U.S. to get protection here. It's a country by country question. You have to get the protection in each country, and the U.S. requires registration to enforce certain rights.
Okay. If you use AI for proofreading, will you lose your copyright? I think you've answered this.
Depends on the service.
Okay. Okay, I created over many iterations a logo on AI, then altered its color. Can that be my trademark?
Oh, trademark. Yeah, it should. As long as that's a different question. That's not a copyright question. So that depends on if you're the first to use it in connection with in commerce in a way that consumers can relate it to your goods or service. So yes, you can use that for your trademark.
Okay. What are your thoughts about writers using AI to create a video trailer about their screenplays, purely a sales tool?
No harm. Like great, just be careful of the service that you use so that you don't lose your copyright in your screenplay, and be aware that the trailer that's created is not going to be protectable by copyright, but your screenplay as long as you don't use bad service, your screenplay will still be protected.
Okay. Can we safely upload our screenplay to dedicated software like Film Ustage for AI scheduling and budgeting or Claude AI?
Depends on the terms of service of each one. You have to read it.
Okay. Can a fan site use copyrighted content and create a derivative work use using AI content by claiming fair use?
Yes, the fans, well, what do they do with it? As long as they're using it at home and they're creating it, for home use, great. That's fair use. If they start posting it somewhere, that's a problem. It's a problem for them, but it's also a problem for wherever they post it, unless there's circular 230, section 230 protection.
Okay. Next, I own the rights to a comic book. I'm creating a 100% AI film from it. Is the film protected by copyright if the AI
Yes.
platform I'm using is owned by my partner?
Well, I missed say the last
The
question.
last part is the AI platform they're using is owned by their partner.
Oh, yeah. The short answer is that that's a perfect example that the underlying, I'm assuming that he wrote the comic. I'm assuming the comic was created by a human. the film that you create will be protected as a derivative work based on that underlying. This is the analogy that I gave of having a human right of treatment, and everything from that will be derivative work and will be protected. So that's the way that's the workaround around the problem of AI output not being protected, is that you have a human do the original work and everything else is derivative and is protected.
Okay, next. My script was uploaded to chat. It lost protection. Practically, what does it mean since no one can download said script?
I think chat is the terms of service that I last read made it public domain. So I don't think he lost it by uploading to chat, is the short answer.
Okay. Next, what happens if someone else uploads my original screenplay to AI?
Now, that's not a problem. It's you have to, whoever does it has to have the authority to have done it. That's the key. So if I upload Star Wars, I don't have authority to give that to the public domain. It had to be somebody at Disney with authority to do it that would cause a problem.
Okay. Which main AI service currently does not make what you upload public domain? Is there a service you currently recommend?
Uh, my last, I believe ChatGPT did not. I'd have to go through them. I went through all of them. And the one that was a serious problem at the time was Midjourney. I don't think Gemini is not a problem. ChatGPT is not a problem, and Midjourney was from when I last read.
Okay, there's one more question left, but I'm not sure that I am even understanding. Does notice to the AI before uploading copyrighted that you retain all rights?
No, I hear that. I understand the question.
Okay,
It's yeah. If you tell AI I'm keeping my copyright, no, it depends on the term. The terms of service would override that.
okay. It looks like we actually have another question here. So if I'm a writer and I send my script to a Disney exec, and that exec uploads the script to AI for
Not a problem. No authority. He did not have authority from you to do that.
okay. And then someone is asking about Claude. What are your thoughts on Claude AI?
Haven't read the term. I don't recall reading the terms of service on Claude.
Okay, it looks like this is the last question. SAG covers AI content made with their actors. If a SAG actor is then in a movie with a Tilly Norwood of sorts, does the SAG agreement apply to Tilly Norwood?
No, no.
Okay. Oh, another question popped in. I think this will have to be the last one. We are over
Okay.
time.
Yeah. Yeah.
So I use AI to help with the treatment, but then write the script. What about protectability?
You're good. You're good. Your screenplay that you wrote will be protected, is the answer. Okay. So let's call that the last.
Sounds great.
We're good? Okay. I want to thank everybody for attending. It's been my honor. And again, if you have any questions, give me a buzz or a note. Talk to you later.